Hello, everyone, and welcome to Immigration and Jobs Talk Show. And before I move ahead, I would like to read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back, everyone. You're watching Immigration and Jobs Talk Show. I'm Rajni, Bharara, your host, and today we are tackling a topic that is both timely and crucial for countless international students pursuing their dreams in the United States. Whether you are about to embark on your academic journey or you're already navigating life as an F1 student, this episode is one you cannot afford to miss. Well, imagine this. You have done everything right. Secured your F1 visa, packed your bags, and prepared yourself for an exciting future. But upon your arrival in the US, you're stopped at the airport, questioned, and before you know it, you're facing the possibility of being sent back home. This nightmare scenario is unfortunately a reality for some students who fall afoul of US immigration laws. So, what can you do to avoid falling into this trap? And also, what are some common pitfalls and how can you safeguard your future? To discuss about all this, we have today with us none other than litigation attorney Jonathan Wasden. So, without any further ado, let's welcome him once again to our show. John, welcome back once again to Immigration and Jobs Talk Show.
Good seeing you again.
Thank you so much. Likewise. And to our lovely viewers, I would like to tell you that we are live on YouTube, LinkedIn, and Facebook. And the handle is Immigration Talk Show. So don't forget to subscribe to us. And if you have any question that you would like to ask from John, so please keep commenting them in the comment section. Keep asking your questions. We'll be glad to take them. And now, John, before I talk about, today's topic, which is F1 students, how to avoid deportation. Before I talk about that, I also would like to ask you about the H1B second round of lottery, which was announced yesterday. So if you can, please provide a brief overview about the second H1B lottery announced by USCIS, and why do you think it was necessary?
Yeah, sure. So up until a few years ago, the way they ran the lottery was they would run everybody through the first round and then get to that 65,000 bachelor's cap. And then they would run the master's cap. So they flipped that, and now they run the master's cap first, and then they run the bachelor's cap. So this year, what happened is the master's cap was full after the first round of the lottery, but the bachelor's cap still was not full. They didn't have enough petitions filed after selection. So they're running the bachelor's cap again. Now, it's kind of a confusing way to phrase it because the people with masters, PhDs, and bachelors all get run through the bachelor's cap all together. So it's for a master's degree or higher, it's really your third bite at the apple. And, bachelor's, it's your second bite of the apple. So to me, the reasons for it, just they didn't get the volume of petitions that they needed to, fully fill up their 85,000. And so they're going to redo the draft. It should happen relatively soon because these visas have to be awarded prior to the end of the fiscal year, and that's September 30th. So I would anticipate we'd be seeing the new lottery in the next few weeks, maybe a month at the most, and then selection notices will be coming out then.
All right. So, and what about the applicants? I mean, what can they expect, and what is that they should be looking out for?
So just updates from USCIS about the lottery being run, and then checking their online account to see if they were selected.
Right. And now that the second lottery has been announced, do you think there's a possibility of also having a third lottery?
I don't think so. I think the second one will probably fill it up. I mean, we're already in August, so we've only got 2 months left in the fiscal year. So I don't know that we have actual time for a third lottery even. So I would expect this to be the last one.
Okay. All right. Thank you so much for answering the questions related to H1B second lottery, John. Now let's come to the topic that why we are here. to discuss the topic that we are here for, which is F1 students and how to avoid deportation. So my very first question about this topic is, so, John, there has been a specific section of US immigration law, section 212A, 6 and C, that has been causing a lot of concern basically among the F1 students. So if you can please explain what section 212A, 6C covers and why it's particularly relevant for F1 students.
Yeah, sure. The 6C finding is what the commonly referred to in immigration world is a fraud finding. It covers fraud or material misrepresentations that were knowingly made by the foreign national in an attempt to get an immigration benefit. So all of those things have to be met in order to substantiate a 6C finding. When USCIS makes a 6C finding in, say, a petition process, that's something that's very easy to challenge and take to court because there's no protections for USCIS going to court. One of the most frustrating things, though, in immigration law is that the law makes decisions at the port of entry bulletproof to judicial attack. And so it's very frustrating because you have very low information CBP officers making decisions on people's lives that have a far-reaching impact, and sometimes they're not doing it with all the best information or best motives at heart. So port of entry is an inherently dangerous situation for anybody coming to the country on a non-immigrant visa.
Okay. So, it sounds like this section covers some serious grounds on inadmissibility, right? So,
Yeah.
So, how often do you see these cases where students are unaware that they violated this section? And do you think more awareness could prevent some of these issues in the future?
So it's really scary because I've seen cases where, the famous one was the Atlanta case a few months back, or maybe actually a year back now, where there was a group of students on a flight coming from India,
Right.
and they all got stopped, sent to secondary, and sent home with fraud findings saying that their F1s were shams or frauds. These students, many of them had evidence on their phones that they had acceptance letters from universities, they had paid for tuition, they had lined up housing, they had done everything in the world to show that they were actually going to school. But some yokel CBP officer decided that, that was fraud. Really, it's just a way to hassle people at the port of entry. I'm not a big fan of CBP. I don't think they do a great job, just full disclosure. And I think they have way too much power and authority for what they do and for the level of knowledge that they have. So it really comes down to protecting yourself from these low information government bureaucrats at the port of entry. One thing that we commonly see happen at the port of entry is your constitutional protections are lower at the port of entry inherently. So unlike a traffic stop or something like that where they need a warrant to search, the rules are more flexible at the port of entry. They can take your electronics, they can take your phone, they can go through your bags. So, you see oftentimes they'll go through somebody's phone, looking through all their old email accounts or WhatsApp messages, looking for anything that they can to, substantiate their theory of what's going on.
Right.
So, you got to ask yourself, is it worth it to carry your phone? Is it better to go without your portable brain for a couple of days, FedEx that to yourself, and then get it when you get here, instead of just exposing yourself to CBP rifling through your private information on your phone? So, that would probably be, something advisable if you're worried about this, just to FedEx your phone to yourself, just to avoid the potential problem that could happen.
Right, but what according to you should be their first step? Because in a situation like this, when you have no clue about anything, and your phones are taken away, and other things. Mostly you are left with nothing, right? And you are
Yeah.
in a country where you don't know what to do and whom to contact. So in a situation like this, what do you think the students should do?
So for F1s, I think it's important to know your contacts. People at
Right.
the school that you've been dealing with, have their phone numbers, have their emails, have their names. So when you're asked any questions, you can give that to CBP and they have somebody that they can contact to verify information. So I would take all of this just in a folder, just paper copies. That way you can just hand it over to the CBP people. Your acceptance letters for university, all of those types of things, proof that you've got housing lined up. All of that would be helpful to have in a tidy little folder that you can just hand over.
Right, right. Okay, thank you so much for answering the question, John. Also, John, I would like to know from you that what are some of the most common mistakes that F1 students might unintentionally make, that could lead to issues of fraud or misrepresentation under this section?
Sure. So there's maintenance of status issues, and then there's fraud issues.
Right.
What USCIS considers to be fraud, I think the biggest thing we're seeing right now is people that were scammed by fraudulent employers who were preying on recent college graduates with F1s, telling them that they were going to hire them, place them on a project, but you just need a little bit more training before they can put you on a project. And oh, by the way, we do the training and it's going to cost you. So that scheme is relatively common, or was more common recently. And anybody that was caught up with one of those companies, eventually at some point or time in the future, you're going to get, sent to secondary. You're going to have problems with, DHS with this issue. It might be at the State Department of the consulate, might be at the port of entry, but those fraudulent scam employers are the biggest threat probably right now that I see to people on an F1.
Mm-hmm, mm-hmm. And are there any support or help available for these students?
So you can request that you be able to call an attorney. Again, at the port of entry, your rights are very limited. If you do carry your cell phone, or if you do carry a dummy phone or a burner phone with you through the airport,
Right.
I would just ask them if it's okay if you can record the conversation so that you have, make sure there's no language barriers or problems with understanding, so you have a clear record of actually what was said. If they have a problem with that, that lets you know you're not dealing with an honest officer. If somebody's afraid to be recorded, that's a red flag. The other thing that I would say is, excuse me, let me grab some water.
Sure.
Now I lost my train of thought. But yeah, I would say, ask them if you can record them. If they say no, be very suspicious of them at that point in time.
Right, right. Thank you so much for that great advice, John. And also, John, given how easily these mistakes can happen, so would you say these issues are mostly due to lack of understanding of the visa requirements, or are there other factors at play too?
So I think a lack of awareness on students' parts about, the scam employers is probably the biggest problem. The USCIS didn't really help anybody out in this regard either, because they were aware of these scam companies out there. They had, identified them, they had blacklisted them and flagged them in the system, and then just waited for people to get caught in the scam. So, what a legitimate, law enforcement agency should do is alert the public that there's a problem out there and to be aware of it. But USCIS almost, fanned the flames here. They knew these companies were in existence. They didn't decertify them from E-Verify. They let people blindly walk into it and then held them accountable for the fraud that the company perpetrated. So, you gotta really advocate for yourself in these situations and really thoroughly vet anybody you're taking a job from to make sure there's no problems. As a general rule, I would say anybody that's asking for payment for training or a letter or anything, you should not only stay away from, but run away from.
Right, right. And any specific advice you would like to give these students to avoid these pitfalls? I mean, so that they don't get into these things. I mean, because
to the extent you can, I mean, social media is a great thing. To the extent you can, contact people that have worked there. Go out referrals from friends. Make sure that if you're on STEM OPT, that you're following all the requirements for STEM OPT, or that company is actually following them. Because if you have a STEM OPT employer and you're not following the training plan or any of that, then if there's an RFE on whether or not you maintain status and you don't have that information, you're going to be in the world of hurt, and you will be found to have not maintained status because your employer wasn't documenting correctly, and then that'll mean you have to consular process. And as anybody knows, consular processing right now is a nightmare. It's the number of 221Gs going out is just astronomical right now, so you want to avoid that as much as possible. So you really have to advocate, and if your employer is not complying with the rules, you should probably look for a new employer, and just to protect yourself, consider reporting it to DHS just so you have a documented history of saying, hey, there was a problem, it wasn't my fault, I'm finding a new employer. So you may have to be a little bit more proactive. Now, that said, if you're going to go that route, highly recommend talking with an attorney first and maybe having them do the letter and them do the correspondence for you, just to make sure that you're not inadvertently saying something that's going to hurt your future.
Right. And is there a way to also find the right attorney for such cases?
Again, word of mouth, people that you trust, just Google reviews, that just look for somebody that has experience in this area that you can trust.
Right, right. Also, John, so beyond misrepresentation, what are the other main reasons, international students might face deportation? And again, how can they avoid finding themselves in, such situations?
So there's two different things. One is non-immigrant intent, and then the other is not having the right travel documents. The travel document one is, I think it's an A7. It's kind of disingenuous for them to give you an A7, because typically what they're saying is, you show up with a valid visa and the CBP officer says, you don't have the required documents because we're revoking your visa, but they're revoking it because of A6 for the fraud finding. And so, you're getting an expedited removal and it's for not having documents, but really it's a lifetime bar because of the fraud finding. The maintenance of status issue is something we're starting to see more commonly recently, where they start, looking into whether or not you're going to be returning home at the end of your stay. We see it a lot on B2 visas, especially, but F1s as well. So they will, be constantly probing to see if your intent at the time you enter the U.S. is to stay permanently, or if your intent is to finish your program and leave. And so, you just have to keep in mind what your non-immigrant intent is. One other thing before I forget, when you get pulled into secondary, if they're going to remove you to a 235 removal, sometimes they will give you the option to withdraw your application for admission. If they ever give you that option, that is the best course of action to take, because that avoids having any bars against you from reapplying for admission. You can go to the consulate, you can do a trip report, you can try and fix whatever the problem is that CBP believes there was, and then reapply for admission. But if you get that expedited removal, it's much, much harder to get back into the country.
Right. And also, it is said that the visa officers also see your intentions. What are your intentions? So how can the student, show their correct intentions to the visa officers?
So for the students, it's a tough one, right?
Right.
Because you're young, you don't own a home, you don't, have a lot of substantial business ties or anything like that.
Yeah.
So it's tough. You just have to, say the truth. You're just coming to get an education. This is the best place for it. And, you probably will, look for OPT to get experience to solidify your education.
Mhm.
For the B2s, what we typically see them looking for is, proof that you have a residence in India that you're going to return to. Again, if you're younger, that's going to be tough to
Yeah.
do because if you're going to be gone for 6 months, you may not maintain an apartment. So, those are the types of things that they're looking for. Again, the system is set up to give CBP a lot of discretion on what they decide. And it really comes down to the eye of the beholder. What does that individual CBP officer think or want to find?
Mhm.
And so that's why I said earlier, if you can record them or request to record them, if they say no, you're not dealing with an honest broker. You're dealing with somebody that wants to just find the facts to support their assumptions.
Right, right.
Along those lines, a lot of times they'll have you do a written statement, or what they'll do is they'll interview you. They will type up a summary of the statement, and then they'll put your signature on it.
Mhm.
They get your signature electronically before the beginning of that interview. And then they affix your signature to that written statement after the interview without letting you see that written statement. And that becomes the official record. So I would not sign anything when you go into that secondary. If they give you that digital signature pad, I wouldn't sign it. I'd say I'll wait until I see a written statement before I sign anything, because I want to make sure it's accurate, and demand that you see that written statement before you sign it. Read through and make sure it's accurate. Make annotations to it if it's wrong. So you really have to be assertive. You really have to protect yourself and advocate for yourself in that situation.
Right. Thank you so much for such great tips, John. Also, I would like to discuss, about this case. I think I don't know if this was the same case that you were also mentioning about the 33 students who were deported at the USA Chicago airport on January 15th this year, 2024. So, this incident has understandably caused a lot of concern. So, how can such cases be prevented in the future?
So the biggest things that I would say is never go through Chicago. Chicago's CBP is notorious. They
Okay.
are, without question, the worst airport in the world to travel through for abusive law enforcement tactics.
And why is that?
It has to do with leadership for that particular office, would be my guess. But it's been bad. I think the people that are working there just have a bias, and it's just someplace I would avoid like the plague if I could. So I would make your port of entry someplace, someplace other than that, or Atlanta. Atlanta's also got an overly aggressive CBP office that, they shoot first and ask questions later, so to speak. So I'd avoid those two places as your first line of defense. Even if it means taking a few extra hours to get to your destination, it's probably worth it.
Okay. And what role can universities and immigration advisors play in preventing these unfortunate events?
So that's a frustrating question, because some of these people, I talked with some of those students, and there is nothing in the world, there's no more information that they could have possibly had or presented to that officer to show that they were a legit student, that they were going to be engaged in a program of study, and everything lined up, all their documentation lined up, but it didn't matter. They just, did the expedited removal and said, you're not coming here to study, and sent them away. Now, these are people right at the beginning of master's programs, these at legit universities, like University of Chicago, some of them, like very, very solid, well-known, reputable colleges. And they had paid tuition, but it didn't matter. They had housing lined up, it didn't matter. So for those people, it's frustrating because there is nothing in the world they could have done to alter the outcome other than possibly change the airport that they flew through.
Right, right. Okay. And, also I would like to take a moment to also discuss about, when students first enter the US. So how do these immigration officials at the port of entry determine if an F1 student is inadmissible under section 212, AC6? So, and what are the key factors? Are there any key factors they consider doing this?
So there's a database that's called the
Okay.
Consular Consolidated Database. And the Department of State, the consulate, can upload information to it and access information. CBP can access the information and upload to it, as well as USCIS. For the OPT scam employers, what they're doing is USCIS is identifying who is associated with these companies. They're going through their records, they're matching up. They rated the companies, they took their list of employees, and then they started matching up names. And so then they uploaded that to the CCD, that database. Now, some of these people stayed in the country, got H-1Bs, extensions of H-1Bs multiple times, and never heard a word from USCIS that there was a problem with their OPT experience. It's not until they go to the consulate or they go to the port of entry that they learn about this. Because the first thing that happens at both the consulate and the port of entry is they get your biometrics and they pull up your file in the CCD. And if there's any flags or any hits in the system, you're immediately going to the secondary, or you're getting focused and attention. And USCIS is flagging people in the system and then waiting for them to go to the port of entry or go for stamping at the consulate, and that's where they're hitting problems. That's the very first thing that happens is they notice that flag and they're pulled in.
Right, right. And let's say that if the immigration officer suspects something is wrong, then what happens next? And how can in a situation like that, how can the student respond during that moment? That can impact their situation.
Yeah. So the first thing to remember, if you get pulled into secondary, by and large, these people are bullies. They are basically mini little Trumps working around and just trying to throw their weight around in their authority. And so it is not uncommon at all for them to try and bully you, intimidate you, yell and scream at you, keep presenting you with a scenario of facts that they believe and demand that you agree with them. And if you don't agree with them, for them to lose their temper and basically throw a tantrum like a toddler. So just be aware that that is their MO, that's their process that they go through. And when it happens, don't get flustered. Just stay calm, disagree with them where you need to. Again, ask for recording and refuse to sign anything, because if they're throwing a tantrum like that and making wild accusations, their summary of your conversation is not likely to be accurate.
Do you have a case, where something similar happened that you would like to discuss with us and the audiences?
Yeah, I mean that's such a common scenario where you get pulled into secondary and somebody starts yelling and screaming at you and accusing you of having done something wrong.
Right.
And no matter what you say, no matter what evidence you bring, in support of yourself, they keep on screaming. It's almost like they have a quota of people that they have to reject at the board of entry. So they're, maybe at the end of the month, you see this happen more as they're hitting their time for their quota. But, it happens all the time. Like I say, some airports are worse than others. But it's not exactly the way you'd want a reputable government agency to behave, but it's how they operate.
Right, right. All right, thank you so much for answering the questions, John. And I can see people have started commenting their questions. So I would like to take a couple of them from the audiences. Okay, let's take maybe Ramesh's. So Ramesh is here and he says, I know this session is for F1, but related to H1B fiscal year 2023. My petition was revoked and back to India. What are my chances to secure my cap number back where there are no fault of mine and issues for fiscal year 2025? What do you have to say, John?
So this is an issue we've been suing USCIS on, and we're not at the end of the process yet, but so far the signs are positive. What we're trying to do is, for people in that situation, is to recapture their cap number that they initially were assigned. Now, when we first started suing USCIS, what was happening was people would be going to the consulate for a new visa category, and they were told that they had a fraud finding applied against them based on their employer's multiple registrations. And so that was game over. They had a fraud finding in the system. We started suing and challenging that issue, and USCIS almost immediately realized that they were doing it wrong, and they changed their policy and the way that they were handling that situation. So now if you're the employee who was, the subject of a multiple registration, you are no longer getting penalized by USCIS. And that's a huge change, and that's a huge, benefit to you. So what that means is on future H-1B lotteries, it shouldn't have any impact on your ability to get a visa.
Right, right. And he also has a second part. He says, my H-1B petition for fiscal 2023 was revoked due to multiple registrations. Even though I wasn't involved, I had returned to India. What are my chances of getting a cap number for 2025? Any advice?
Yeah, there's not going to be anything, ideally nothing that is going to follow you or impact you from that multiple selection. If you get an RFE on it, we should talk and strategize for how to respond to that, because USCIS is on record in all kinds of court documents saying that they will not penalize the employee for the employer's alleged misconduct. So it shouldn't have any impact on your 2025 petition. I think you should be fine there.
Right, right. Okay. So Ramesh, you don't have to worry. And yes, thank you so much for your question. Let us know if you have a follow-up or if you'd like to know an answer to another question. Thank you so much for posting your question. Let's quickly take RK's question also. So RK is here and he says, is there any truth that attorneys litigated against USCIS asking employers proof having a project before approved, because few employers use not requiring to show proof to take a genuine cap and bench their workers while looking for a project, while genuine students miss out? We know it's wrong what they are doing, but last chance students are losing out.
The structure of the H-1B lottery system is very flawed, I guess, to say it in a very kind way. The lottery is held in March. And if you're working for a staffing company, the industry standard for a lot of these companies is to operate on 6-month projects. So the best case scenario is if you get selected, you get approved, and the stars line up and you get a visa stamp and you're able to enter the country by the beginning of that visa period, you're already past 6 months. And so it's almost impossible to have a project that's guaranteed at the time they file your registration. And really, no employer in the world is going to sign a legally binding contract for an employee to work at a client site when they don't even know the outcome of the lottery yet. And so it's really impossible to have that project requirement. And more importantly, that's just not my view of it. It's what the law says that Congress created. So the Congress, when they created the H-1B restructuring, what they said is that you can legally bench people, but you have to pay them while benched. And so that's the protection, that's the trade-off, is that employers can take that risk. But once you're in the country and available for work, if they're not paying you, they have a substantial legal liability. And so that's the system is flawed, but that's the best remedy that people have. I think his question is really going more towards the people that were selected in the lottery still in India and are not able to get visas. That's a tough one, because if the employer doesn't have a project and they are not going to bring you, there's not much you can do there. But it's really more a flaw in the system than it is in the employers doing something wrong.
Right. He also has one more question. I would like to read that out. He says, how is it that the selected 130K with a 20K for the master cab, which was filed, for the remaining 110K, they weren't able to get 65K? Does this indicate employers just registering applicants?
Yeah, probably. There's a gap there. They registered, then business situations change. We're now, like 5 months past the initial lottery. A lot changes in 5 months. If you look at the tech industry, there's a lot of layoffs going on. And I think the rate of filing petitions kind of tracks the greater tech industry in general. So as the tech industry is shedding jobs, there's really not a need for those H-1Bs you'd anticipated coming into the country and working on H-1B. So, a lot of things in the business world can change and impact filing rates. And I think that's probably what we're seeing here.
Right. Thank you so much, RK, for your question. I hope you've got the answer. We still have a lot of questions from the viewers, John. But before I take them, I would like to go for a short break. And after the break, I would like to take these questions from the viewers, if that's okay to you.
Sure.
All right. So, guys, it's time to go for a short break. But you guys don't go anywhere, because post the break, we are going to take up questions from you. So, yes, keep on watching Immigration and Jobs Talk Show and stay tuned with us.
Consultant seeking a new opportunity? We offer job placement. Consultant seeking a new opportunity? We offer job placement services for U.S. citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 732-707-9151 or mail us at rajni@higheritpeople.com or visit our website www.higheritpeople.com. Consultant seeking a new opportunity? We offer job placement services for U.S. citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards.
Welcome back, everyone. You're watching Immigration and Jobs Talk Show. I'm your host, Rajni, and today I'm here with none other than immigration litigation attorney Jonathan Wasden. And today we are discussing about F1 students, how to avoid deportation. And yes, we are getting questions from you. So now, without any further ado, let me take another question. So the next question that we have is from Vishwa Das. Let's take Vishwa's question. He says, currently on F1 visa and my program end date is in 2 months. However, I need more time to complete my thesis. Can I apply for a program extension? And if so, what documentation do I need to provide?
So if you're still working on your program, theoretically, you should be able to get an extension of that. Now, the caveat being is you got to know your limitations. My limitation is I don't file these petitions. Yeah, I litigate on the fraud findings, I litigate on denied petitions, and kind of try and fix things that were broken in the process after the fact. So I would say talk to an immigration attorney that actually files this type of petition, because they're going to have standard formats that they've done this 1,000 times, and they can run you through it, and they can give you that information, and they can line up your package to make it as strong as possible to get what you need done.
Right. Okay. So Vishwa, I hope you've got the answer. Thank you so much for your question. Let us know if you have another one. Meanwhile, let's take Imran's question. So Imran says, I am on F1 visa and got married to a US citizen. Can I apply for a change of status to a spouse visa, CR2, or do I need to leave the US and apply for CR1 visa?
So if you're married to a US citizen, you would be looking to adjust status, and you should be able to do that while you're here in the country. So, I don't know that you would need to leave the country. Again, the caveat being I don't file these. It's not my area that I practice in on a regular basis, the family petitions. But my understanding is you can stay in the country while you make that application.
Okay, and he also has a part two, John. He says, what are the benefits and drawbacks of each option, and what are the required documents and filing fees?
So if given a chance, seeking immigration benefits for marriage to a U.S. citizen is always your top choice. There's really no easier or better way to get that. Now, with U.S. citizens marrying foreign nationals, there is a lot of scrutiny that they give your application. They look for evidence or indicators of marriage fraud, things like that. So you're really going to want to go through and just show that the marriage is bona fide, and probably pictures of dating time, pictures of weddings, lists of who was at the wedding, things like that, just to show that this was a legit marriage and it's not just for the purpose of getting immigration benefits. Signs of cohabitation, shared utility bills, shared leases, shared addresses. Just anything that shows that you are a married couple is going to be very useful for your application. And the filing fees, like I said, I don't file these, so I don't know off the top of my head what the filing fees are. But you can just Google that on USCIS's website, and it'll pop right up.
Right. So you can check that out on USCIS website, Imran. And thank you for your question. Let us know if you have another part or a follow-up or maybe another question for John. Let's take Deportation's question in the meanwhile. And he says, I have received an RFE on my F1 visa application stating that my bank statement doesn't show sufficient funds. However, I have since deposited more money into my bank account. Can I submit an updated bank statement, or do I need to reapply entirely?
So if you haven't replied to the RFE yet, you can provide the new bank statement. If you've already replied to the RFE, you can try and do a supplemental. A lot of times USCIS will not accept the supplemental filing, but you can try. There's nothing that says you can't do it. So, I would say if you're past the point where you're outside that window of the normal reply time, maybe reapplying would be the way to go.
Right. So, Dipesh, I think, like John said, you should reapply then. Then Paul is also here, and Paul says, I was on F1 visa and worked part time for 6 months without authorization. I have since stopped working and want to apply for OPT. Can I apply for OPT, or will my unauthorized work impact my eligibility?
If USCIS knows about the unauthorized employment, it will definitely be a problem. And that is one thing that they are, when they have that information, they don't always have it. A lot of times there's no way for them to know. But if they have that information, it's definitely going to be a problem for you. Unauthorized employment as a student can, create a 3-year bar to re-entry into the U.S. So it definitely will be an issue. My guess is if they have any information about that, they'll be giving you an RFE or an NOID. And so you'll be responding to that.
Right. So, Paul, thanks so much for your question. I hope you have got the answer. Ramesh's question, I think we already have taken. Vishwa's question also, I think we already took. RK also, I think we already have taken. Alok is also here, and he says, I have been on F1 visa for 6 years and have completed 2 master's degree. I want to apply for a PhD program, but I'm concerned about the impact on my F1 status. Can I apply for a third degree on an F1 visa, or do I need to change my status to an H1B or J1 visa? What are the rules and regulations regarding F1 status and multiple degrees?
So typically as long as you're, advancing, making progress up the educational ladder, you should be fine. So a PhD, it's kind of a natural progression. You go from bachelor's, master's, PhD. So I wouldn't expect that to be a problem for you. I would expect if you filed for a third master's degree to get a lot of scrutiny in the application process. But for the PhD program, I think you're fine. But if you have the option of an H1, why not go for that and then do your PhD in part-time. The one thing I will caution about PhD programs is just make sure that it's from a legit university, because they have a list at USCIS of colleges that are suspect, and degree mills, things like that, places that only exist to issue CPT. And you don't want to be involved with one of those colleges. You want to be with a no kidding university that has a PhD program that has some legitimacy.
Right. But John, is there a reason behind the lot of scrutiny that you said?
Sorry, say again?
So is there a particular reason about the scrutiny that you mentioned?
Yeah, because it questions whether or not you're really looking to get an education, or if you're just really trying to stick around to work. And so if the immigration agency looks at it as you're just trying to game the system to work, they will inquire further into your application.
Right. Thank you so much for answering the question. And Alok, thank you so much for your question. Let us know if you have another follow-up or maybe another question. Meanwhile, Biraj is also here, and he says, I'm on F1 visa and was recently arrested for a DUI. Will this affect my F1 status, and can I still apply for OPT or a green card in the future? Okay, let's
So
take
it could impact your F1 status.
Mm-hmm.
So typically the way these things work is your arrest record gets reported to DHS. DHS uploads that to the consular consolidated database, you're flagged. Then it goes to the consulate, and the consulate decides whether or not to revoke your F1 visa. If they send you an email, and I would keep an eye on your spam folder, I would keep an eye on your email inbox. If they send you an email contacting you saying that your F1 is revoked, what that means is you don't have to leave the country right away. You just won't be able to come back into the country once you leave. So it shouldn't be, a problem for finishing your program. I doubt it's something that will come up in the OPT process. They could RFE you on it, but it's not one of the things that they would typically, focus in on an OPT.
Okay, and he also has a second part, and he says, what are the potential consequences of a criminal record on my immigration status?
Yeah. So, the real problem is going to be going for stamping, or whether or not you maintain, if they're going to find that to be some type of violation of your non-immigrant status. USCIS may deny a change of status or an extension of status. Probably not the most likely outcome. The most likely scenario is going to the consulate and the consulate making a decision on you because of your criminal, conviction for DUI.
Right. Okay, so Viraj, thank you so much for your question. I hope you have got the answer. Malika Arjun Rao is also here. Let's take his question. So he says, I am currently on an F1 visa and want to transfer to a different university. Can I transfer my service record to the new university, or do I need to apply for a new F1 visa?
So again, limitations are, I don't file these, but I believe you can transfer to a new university without having to file a new F1 visa. So, talk with your DSO, the designated school officer or the DSO. They know this process backwards and forwards. So, get an appointment to go in and speak with them about how to do that. Now, if you're transferring universities, again, the caution I give everybody on F1 is make sure the university you're going to is not a degree mill. It's not a CPT mill. It's a legit university that's offering legit course of studies, that it's reputable. And that's, very important for avoiding problems in the future.
Right. And he also, again, has a second part, and he says, what are the requirements and procedures for transferring my service record?
Yeah, again, you want to talk to your DSO, and the DSO will be able to walk you through that whole process.
Okay, so Mallikarjun, I hope you have got the answer to all your questions. Thank you so much for posting them in the comment section. And John, I also have questions from the viewers actually on my WhatsApp. So let me quickly read these questions. I'm so sorry, I'm taking a bit time. Okay, so here it is. The question is, will I be deported if I say that I'm staying at my friend's place because the university is close to his locality?
You mean, I guess they're asking if when they're coming through the port of entry, if they're asking where they're living. That wouldn't necessarily be a deal breaker. But if you have a lease or you have some type of documentation of where you're going to be living, that would be best. If you have some type of agreement with your friend to split costs, if you can get that in writing, that would be a great piece of information to have. But just staying at a friend's place isn't going to be a deal breaker. People have roommates all the time, so.
Okay, all right. Thank you so much for answering the question also, John. And again, okay, so I have one more question for you. And this question is actually from a guy, and he says, I already got my F1 visa, but just after, where is it? I already got my F1 visa, but just after it was issued, my I-130 filed by my stepmother got approved. Will this be a problem at immigration?
I've never seen that scenario come up. It shouldn't be. Although typically when you have an immigrant visa petition and a non-immigrant visa petition, they focus on your non-immigrant intent. What are you going to do? I don't know how long the wait period is, for a I-130 in this situation, but you're just going to want to make clear that at the end of your F1 program that you plan to return back home until your priority date's current. You can get a visa on the 130. And that's really going to be the issue. What is your non-immigrant intent coming in on the F1?
Right. And I also have one more question. And the question is, where is it? Okay, what should I do if my F1 visa got revoked and I received a 5-year ban? Can I go to the USA for my studies again?
So it really depends on why it was revoked. If it was revoked with a fraud finding, no. You're going to have to deal with that fraud finding before you can get another visa. If you're still within that 5-year ban window, you're going to have to, get a waiver for that, or figure out a way around that. But if it's not for fraud and you're outside that 5-year period, theoretically you should be fine. Now, when you go for stamping, or you go for, the port of entry, they may ask you questions about it, and you just have to, answer that as best as you can. I'd say consult with a, immigration attorney before you go to the consulate or before you go to the port of entry, just to get some, pointers on what the questions will be based on your specific facts, and how best to answer that based on your history.
Right. And, these are some questions posted in some groups. So we try to look for these questions also. And one more question, one last question for this episode. I got my USA visa on 12th January, and I'm going to the University of South Dakota in July. I have paid my enrollment deposit and first semester fee, and all my documents are legit. However, I'm afraid due to the recent news about deportation involving students from South Dakota. Any suggestions?
So I hadn't heard about students in South Dakota facing issues. My first suggestion would be buy the warmest clothes you can possibly find, because South Dakota is the coldest place I've ever been. But in terms of documentation, same rules apply. Just make sure that you've got proof that you can pay for the tuition, or you have paid for the tuition. You've got housing lined up. Correspondence back and forth between the school, if you've got it. Have a contact at the school that can vouch for you and say, yes, they're coming. Yes, I've been discussing with them. Just make sure that you have all of your bases covered when you go through the port of entry. And again, Chicago might be convenient to South Dakota for the port of entry, but I would avoid it. I would look for a different place to go as your initial stop in the U.S.
Right. Okay, so John, one last question before I let you go. Any last feedback or any last suggestion for the F1 students, who might be worried about their deportation at the moment?
Yeah, so I would say you have to be your biggest advocate. You have to be assertive, and you have to look out for your future. So, when it comes to picking a university or a college for a program, make sure they're legit. Make sure they're reputable. They're offering real courses of study, and it's not just a degree mill. When we're talking about post-employment on OPT, make sure that they're following the rules. The employer's following the rules. Watch out for people that are asking to, receive money for you to work for them. Avoid those types of situations, and make sure. There are worse things than being unemployed and having to return back home because you don't have a job. And that worst thing is never being able to come back into the U.S. again if they find you have committed immigration fraud. So, be very, very careful with your choices on F1, and you've got to protect yourself that way.
Right. Thank you so much again, John, for coming and doing the show. It was, again, a great episode. And to our lovely viewers, I would like to say that if you want to get in touch with John, so you can give him a call at 844-592-7336. I would like to repeat the number, 844-592-7336. You can email him at support@wasden.law. Is that right, John?
Correct, yes.
Yeah. And you can also visit his website, which is wasden.law. So you can also check that out. And if you're looking for a project placement or visa sponsorship, you can reach out to me on my number, which is +1 732 707 9151. My email is Rajni at higheritpeople.com. And our website is www.higheritpeople.com. Remember, we sponsor H-1B visas and other work visas based on job availability and regulations. All right. With that, thank you so much again, John. Hoping to see you next week with another great episode and great topic.
It's good being with you. Thank you.
Thank you so much. And to our lovely viewers, thank you so much again for turning in such huge numbers and continuously posting your questions, asking your questions. It really means a lot. If you like the episode, don't forget to like it, share it, and also comment down below. And yes, keep watching and keep subscribing to Immigration and Jobs Talk Show. We have 2 more webinars coming up at 12 and 2, so don't forget to check that out. And for now, I will have to take your leave too, and I'll be meeting with you soon. But yes, for now, I'm Rajni Bharara signing off. You guys take care and keep on subscribing.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 732-707-9151 or mail us at rajni@higheritpeople.com or visit our website www.higheritpeople.com.